Hello. So today we want to talk a little bit about wills versus trusts, okay, and when one makes sense versus the other. So first, let's define each so we have at least some basic understanding of what they are. So a will is a document that tells people where you want your assets to go. It's as simple as that. And I say that because you can have a will on a napkin, okay,
Right.
as long as it's properly endorsed, notarized, all that type of stuff. So that's what a will is. This is what I want to see have happen. Okay. Now, a trust is a little bit more complicated, and in these day and age, everybody's using AI or Chat GPT or something like that. So when you put a definition of a trust in AI, and there's no way I'm going to repeat this as well as a machine, so I'm going to read it for you. It says a trust is a legal arrangement that allows one party, known as the grantor or seller, to transfer assets such as money, real estate, or investments to another party, known as the trustee, for the benefit of a third party, known as the beneficiary. The trustee holds and manages the assets according to the terms and conditions specified in a legal document called a trust agreement or trustee. Breathe. Okay, so you got that? Probably not. But in layman's terms, okay, a trust is an entity that is charged with managing the property of another person for its beneficiaries. And that's simply what a trust is. So now, what are some of the differences between will versus trust planning when you're doing your estate plan, Jason?
Okay, so the first thing you need to think about is a will. Anything you have in a will, it will go through probate. Okay, and probate is a long legal process that not only takes a long time, but it also could be very costly.
Right.
So a trust could be used to avoid probate. So if you put your assets inside of a trust, you could potentially avoid probate.
Right.
That's one big difference.
And to differentiate, you don't put your assets in a will. A will is just that document,
Right.
So that's one of the issues, that a will is just a piece of paper that says, once I pass away, these assets that were still in my name need to be reassigned, and that's the probate process in a will. Whereas in a trust, which is an entity, you're actually reassigning the ownership upon death into the trust and avoiding the probate.
That's right. Exactly. Yep. So you also, with the will, the fiduciary must be established and confirmed by the court. So the executor must be established by the court.
Right.
And who knows if that's going to be the person that you wanted to be assigned to play that duty. But a trustee, with a trust, you can assign a trustee, and that's appointed immediately.
Right.
So you get to control kind of who manages the distribution of your assets. So the other thing is you really have minimal control with a will over how the money gets distributed on your passing. Whereas within a trust, it does provide a lot more control, and there's all types of ways that you can control how that money's distributed and who it is distributed to. So that's the benefit of the trust.
And not that the will doesn't say how you want it distributed, but again, the trust goes a step beyond that, giving you some extra control measures, which are usually based on age or, life accomplishments. Oh, if you've got children, I don't want them to receive it till they graduate college.
Right.
So you can put those extra measures. It's almost control after death.
That's right.
Okay.
Yeah, I mean, you could even go to the point like, hey, I want to make sure that you're working if you're going to receive some of this trust money, so you just don't live off the trust and not do anything. You can do all different types of things within a trust. So the other thing is the privacy side of it. So with a will, that's public information. On your passing, basically anyone can look up what's in your estate. However, with a trust, that is private.
Right.
So it is not public now to the community. So with a trust, you can have some form of asset protection. So for example, let's say you have a son who goes into their second marriage, and this next spouse you're not so sure about. And you don't know if you want that spouse to somehow potentially get a portion of your assets. So you can put some types of protections in there to make sure that the money only goes to the son in that scenario.
And beyond. Yeah, this is legacy planning. Say, I want this to stay in our family, so it's going to go to my son. If my son's not around, it doesn't go to the spouse. It goes straight down to the grandchildren if there's something in that scenario like that.
Now, the benefit of the will is it's definitely a lot more cost efficient. I mean, it doesn't cost a lot to establish a will. So that is one you said you can do it on a napkin, which doesn't cost much at all. Right. Whereas a trust could cost, a few $1,000s plus, depending on how it's set up. Now, one thing to think about, if you do have a will, sometimes you can establish a will so that upon your passing, it establishes a testamentary trust. Right. So that is, if you are going to do a will, then that is a consideration that you could have that set up.
Pros and cons of wills and trusts. And we're not recommending one versus the other. We just want you to be well informed so you can make a decision of what makes sense for you. And of course, speak it to an attorney as to see what's most appropriate for your situation. But when might a trust make sense? Okay, typically speaking, one scenario is when you have mixed families, right? So you have a situation where you've remarried and you have children from a former marriage, or your spouse, or a combination, the Brady Bunch syndrome. Okay, so that might be a great time for you to be able to delineate who gets what, make sure no one's excluded. Okay, this is some of those controls that you can put inside of a trust. Okay, that a will does not have that, ability to do so effectively. Okay, another time when it may make sense, if you have a child that has some type of incapacity, some type of disability or special needs, there are what are called special needs trusts, you can establish to make sure that the funds, the assets are taken care of and managed appropriately and effectively for that child or that heir. Okay, it may not be a child, maybe an adult with special needs. Okay, so that's another time. And third, again, as you mentioned, when you want some of that control at death, after death, and when does that come into play? Usually when there's some distrust happening. We've seen all kinds of situations in our time being financial advisors, but there's times where a child may have some substance abuse issues and you don't want the money to be squandered, so you can put some controls in there. Another time is I've seen it when you have a child at play and you want a family member to be the custodian of that child, but don't trust their financial management skills necessarily. You love them, you think they're going to love your child, but maybe not the best stewards of money. Well, you can have a trust control, help that custodian along and how to distribute the money for that child.
That's right. So another thing to think about when it would make sense for a trust is if you have a significant amount of non-qualified, meaning non-retirement money.
Taxable monies.
So in your retirement accounts, like 401ks, IRAs, you have defined beneficiaries. So at your passing, that immediately goes to the beneficiary. However, with the taxable accounts, if you don't have a trust or you don't have a defined beneficiaries, which most don't, then that could go through probate. So that's another time to consider a trust. So if you want to be, which I mentioned before, if you want to be a little bit more intentional about your legacy planning, another time where it would make sense, again, the scenarios where, your children maybe marry someone that you don't really want those monies to go to, or you're unsure, you can put some controls over there. And even for that to pass down to the next generation as well, you want to make sure that happens. Then a trust would make sense. And again, if you want your monies to remain private upon your passing, your estate to remain private upon your passing, and you don't want some unknown cousin to show up and just say, oh, hey, I didn't realize I had $5 million. Let me see what I can get of that. So that's another scenario.
That's right, Jason. And there's times when a trust may not make sense. It may be a will plan is fine. Okay. One of those situations is when every account you have does have a designated beneficiary. If all you have is a 401k, IRA, and maybe you've been diligent enough to go to a few bank accounts and put what's called a transfer on death or beneficiary on your bank accounts, simple estate may not require a complicated estate plan using a trust. Okay. So simple estate in terms of breadth of assets and amount of assets. If you don't have a significant amount of taxable assets, you may not need to do a trust and spend the monies doing that, okay? Or if you don't have a complex family situation, one marriage, okay, and kids from that marriage, and again, all of the above.
Yeah, kids are doing well, you trust the kids, they're doing well.
Right. So there may be situations where a will is perfectly fine. So again, our goal today was not to necessarily encourage one versus the other, but to give you some ideas and things to think about when you do visit with an estate planning attorney to help see what's most appropriate for you. We hope this helps, and we hope to see you soon.